Good morning, everybody. My name is Nigel Nordone. I'm the head of tax here at Qdos. And today I'm going to be talking to you about the IR35 reform and complying with the off-payroll rules that come into force on the 6th of April of this year. If you have any questions during the presentation, if you could submit them via the Q&A panel, and I will answer as many as I can in the time left at the end of the presentation. So in this session today, I'll be talking to you about what are the off-payroll rules, understanding your changing obligations, ensuring compliance with the new rules, and how to manage the rules before and after the 6th of April. So what are the off-payroll rules? Before we look at the new rules, just a brief overview of what is IR35. IR35 is a tax legislation which tries to distinguish between workers who are generally operating in a self-employed way and those that are essentially being seen and treated by their clients in the same way the client sees and treats their employees, but are still using a limited company. And HMRC say that's just a way of avoiding tax. These people should be employees and not classed as self-employed. So when HMRC carry out an investigation currently, what they are trying to do is establish what's known as the hypothetical contract. If you look at this slide, you can see this is what a fairly typical client worker engagement chain. So you have the end client that has a contract with the agency known as the upper contract, the agency that has a contract with the limited company known as a lower contract. So HMRC say, well, look, typically the terms and conditions in the lower contract differ to those in the upper contract. So they say if you strip those things out, if you ignore the agency, ignore the personal service company, and that worker was working directly to the end client, are they operating in a genuinely self-employed way, or are they being seen and treated by the client in the same way as an employee? If HMRC can show that the contractor is being dealt with in the same way that the engager deals with their employees, they've created the hypothetical contract. The contract therefore would be classed as inside of IR35, and the contractor then would have to pay tax and national insurance in the same way as an employee would. So that's all HMRC are trying to do when they carry out an investigation. Now, in order for HMRC to create this hypothetical contract, they have to look and consider the key status tests, the key tests that decide whether someone is generally self-employed or not. Now, these tests were first set way back in 1968 in a case called Ready Mixed Concrete versus the Minister of Pensions. And in that case, the presiding judge, Judge McKenna, set out three key factors, three key tests that have to, he said, that have to be present for someone to be classed as an employee. And they are personal service, which everyone knows as right of substitution, control and mutuality of obligations. I'm an employee of Qdos, therefore all three key status tests are present within my contract and within my working practices. I can't send a substitute to do the work for me. Qdos has the right of control over me, over what work I do, and where I do it from, and when I do it. And there's a mutuality of obligation between. There's an obligation on me to turn up and do the work, and there's an obligation on Qdos to provide me with work if I turn up, and if I do the work to the standard that they want, to pay me for carrying out that work. So as an employee, all three key status tests are present. So conversely, if you were generally self-employed, then at least one of those key status tests wouldn't be present. You could either send a substitute, you wouldn't be controlled, or mutuality of obligations doesn't exist. What Judge McKenna did in the Ready Mixed Concrete judgment were, in addition to set out three key status tests that need to be present for someone to be an employee, he set out key differentiators, if you like, between someone who is an employee and someone who's self-employed. Judge McKenna said if you're self-employed, you have a financial risk. You have the risk that you don't get paid for the work. You have the risk that, you know, something could go wrong and you have to correct faulty work in your own time at your own cost. You wouldn't be considered part and parcel of the organisation that's engaging your services because you're being brought in for a specific piece of work, and after that work's finished, then your services would no longer be required. If you're self-employed, you'd have business trappings. Obviously, back in 1968, they're a little bit different to what we expect today. Today, we'd expect contractors to have their own website, their own email addresses, mobile phones, laptops, etc., etc. And if you're self-employed, Judge McKenna said, well, you don't have to be exclusive to one client. So you could have multiple client contracts on the go at the same time. So when it comes to deciding someone's employment status, what HMRC do is they look at the contract and they look at the working practices and they try and apply those 3 key status tests to the working practices. And if they can show that the contractor doesn't have the right of substitution, that they're controlled, that mutuality of obligations exists, then they've created what's known as a contract of service, therefore one of employment, and IR35 rules come into force. And that's all HMRC are trying to do when it comes to any investigation, any inquiry. And essentially, when we represent clients in respect of an inquiry, we're trying to show that at least one of those 3 key status tests aren't present. And if we can do that, the contract would be deemed outside of IR35. The lesser test, the financial risk part and parcel, business trappings, exclusivity, other arguments you use to support your argument as to why someone should be classed as generally self-employed. So what is the IR35 reform? Essentially, IR35 was first introduced way back in April 2000 by the then Chancellor of the Exchequer, which I think was Gordon Brown, and it came out in an Inland Revenue Bulletin number 35. So then someone decided to call it IR35. So since 2000, contractors have been responsible for determining their own IR35 status and shouldering the risk of non-compliance for nearly 20 years. So if HMRC carried out an investigation to a contractor and deemed them that they were being treated by the client in the same way as an employee, then they become an employee of their own limited company, and therefore any income they've earned as part of that contract is then taxed under pay as you earn. So they have to pay tax, NIC, employers NIC. From 6th April 2021, the legislation puts the burden of responsibility on the end client engaged in the contractor, a rule which was implemented back in the public sector in April 2017 and was due to come into place in the private sector in April 2020, but obviously due to the COVID-19 pandemic, it's been delayed 12 months. And as far as we know, it's definitely going ahead on the 6th of April. And the fact that the IR35 legislation was entered into the Finance Act last July pretty much confirms our belief that it will go ahead this year. And the new rules, the off-payroll reform rules, will only apply to services, payments for services that are supplied post 6th of April. So what are the off-payroll rules? In short, from April 2021, medium and large companies in the private sector will be tasked with setting the IR35 status of the contractors that they engage. As part of these changes, the IR35 liability which contractors carry currently in the private sector will be transferred to the fee-paying party in the supply chain, and this will either be the client or the agency. So the responsibility for determining the contractor's employment status passes up to the end client, where they are classed as a medium or a large business. So what's the definition of a medium or large business? A medium or large business is one which meets 2 or more of the following conditions: an annual net turnover of more than 10.2 million, a balance sheet total of more than 5.1 million, and more than 50 employees. So if you as a business can answer yes to 2 of at least 3 of those key criteria, I'm sorry, we appear to be on the slide after the one I'm on. So if we could just pop back one slide. Yeah, so if you as a company can answer yes to at least 2 out of those 3 criteria, then you will be classed as a medium or large business by HMRC. The small companies criteria applies to the aggregate position of a group of companies using the definition of the Companies Act 2006. So even if your business in isolation is classed as small, but is part of a wider group, you may still need to consider the off-payroll rules. So if your business, for example, couldn't answer yes to all 3 of those, but you were owned by a larger corporation, then the chances are you would still be classed as a medium or large business. And the payments, it applies to services provided after the 6th of April, as I said earlier, and not in relation to payments provided prior to this date. So the new rules come into force on the 6th of April. So any contractor that has been paid up until the 5th of April, they are still paid under the rules that we are currently operating under, not under the new rules. So who do the rules apply to? Where the end client is based wholly overseas, the contractor is responsible for their IR35 status regardless of the contractual chain. So where the client's based overseas, the responsibility of the PSC contractor, and no other party need consider the rules regardless of the contractual chain. Everything hinges on the end user. So if you're an agent in a contractual chain with a client who is based wholly overseas, you will not need to consider IR35. I mean, I'm not a fan of HMRC, and I usually am fairly disparaging a lot of what they do. But when it comes to deciding who the status determination statement should be issued by when it comes to the overseas clients, I will say this in HMRC's favour, as much as it bothers me to do so. They have actually made this part of the legislation clear. So what constitutes a company being wholly overseas? For a company to be considered wholly overseas for the purposes of the off-payroll rules, the company must not be a UK resident nor have a UK permanent establishment. If you're an overseas client but do not meet these criteria and are therefore not wholly overseas, your business will still be responsible for determining the IR35 status of your UK resident contractors, and you'll be responsible for issuing the status termination statement, i.e. the off-payroll rules will apply. If the business does not meet their obligations, it will as a consequence be liable for the tax and ICs where the rules apply, and HMRC will pursue this debt through the company's UK permanent establishment. The end client who is responsible for issuing the status termination statement will only discharge their liability once they've issued that statement and made sure it's got to the relevant parties in the contractual chain. So a UK resident is incorporated in the UK with certain exceptions, or the central management and control of its business in the UK. A UK permanent establishment is a fixed place of business, e.g. a branch, office or factory. An agent who has habitually exercised authority to do business on behalf of the client, and a company can also reference individuals that are not companies. And like I said, given the due, HMRC have actually set this out quite clearly within their employment status manual. So if you've ever got 10 minutes to kill and you fancy reading about it, it's there for you. So understanding your obligations when it comes to the off-payroll reform post 6th of April. So the client organisation. Clients must assess all off-payroll workers for IR35 status and provide a statement confirming the determination made and the reasoning, a status determination statement. The client must have a client-led disagreement process to handle disputes, and you have 45 days from the time the contractor files their dispute or disagreement with your decision to respond, and you must provide information that requests excuse me, you must provide information when requested regarding the size of your business. So obviously you need to make clear to the people in the contractual chain whether you are a class as a medium or large business or not. The fee payer or the agency, they must deduct the tax and national insurance at source where applicable before paying the limited company or utilise alternative payment options, e.g. umbrella companies. And it's the fee payer, the agency, that will carry the IR35 liability in most cases. But like I said, that responsibility passes down to the fee payer only once the client has discharged their responsibility by issuing the status determination statement. So transfer liability with obligations. So the SDS is passed along until it reaches the fee payer. Another element of the off-payroll rules to consider is the transfer of the status determination statement from the client to the fee payer. So the end user, the client, issues the IR35 statement, the status determination statement, and they pass that to the first agency in the chain. And then the first agent in the chain must then pass that down to the fee payer or to the limited company contractor. Where there's an offshore agency in the chain, it is the responsibility of the UK parties to ensure that the process is followed. Where the fee payer is offshore, however, the last UK party in the chain before the limited company contractor will be responsible for deduction of tax and NIC contributions and paying these to HMRC. The offshore party does not take on any responsibility under the off-payroll rules. So if it's an offshore agency, when you look at this slide, you've got the client who issues the status determination statement to agency one. Agency one would normally pass that down to agency 2. However, agency 2 is offshore, and so it's agency 1's responsibility to ensure that the fee payer gets the status determination statement so they can pay the correct amount of fees or correct amount of monies to the limited company contractor, because the agency that's offshore doesn't have the responsibility to pass the status determination statement down the chain. So if agency 1 just passed it to agency 2 who are offshore and didn't take any further responsibility, then they will have not discharged their duties. So when it comes to issuing a status determination statement, once the end client has issued the status determination statement to the agency, they have discharged their responsibility and their risk of liability, provided that they have taken care. Now, HMRC only provide the definition of reasonable care this year. And as you can see on the slides with the 2 boxes on, as reasonable care is defined as seeking the advice of a qualified professional advisor, checking existing determinations to ensure they remain valid. I'm not sure you can actually see this slide. I think it's the slide before the one you're currently looking at. Regularly reviewing the processes being applied and making new determinations if there are material changes. So that's what HMRC classes as reasonable care. What HMRC classes not taking reasonable care is the end client issuing blanket determinations, which we know has happened with a few businesses, failing to take into account all relevant evidence, and absence of a proper support or training within the organisation. HMRC expect due diligence, i.e. and reasonable care to be taken. So you can't just do everything right at the start of the off-payroll reform in April and then not keep reviewing this and your processes and ensuring everything's in place going forward, because HMRC would say that isn't taking reasonable care, that is not showing ongoing due diligence. So the importance of complying with your obligations. If you don't fulfill your obligations, the liability will sit with you. As I said, the end client discharges their liabilities, the risk to them, once they've issued the status determination statement, and when they do that, they can show they have taken reasonable care. HMRC will use a specialist team to carry out the compliance activity. It was recently announced by HMRC that they are setting up a specialist team to keep track of IR35, the new rules. And HMRC have said there'll be no penalties for the first 12 months unless they believe the actions that are taken are deliberate. And then the end clients will be liable, and fee payers, etc., who become liable are liable for backdated tax and interest that should have been deducted at source during the engagement for all relevant PSC workers. So obviously, if a status determination statement is issued and HMRC say that status determination statement should have been classed as inside and not outside, and there's additional liabilities, then HMRC will go back to the date of the original status determination statement that they believe is wrong, and therefore there'll be backdated tax liabilities and interest calculated when the settlement is calculated by HMRC. So to demonstrate how large that liability can be, depending on the number of contractors you engage and also the importance of not relying on CES, which we'll come on to shortly, NHS Digital are a perfect example how it can let a business down. NHS Digital took the correct approach in using case-by-case assessments. They followed HMRC's guidance and used HMRC's CES tool to undertake them. However, despite using the toolkit supplied by HMRC, NHS Digital reported in their annual accounts for the 2018-19 tax year that following a challenge from HMRC, the public sector body was forced to accept HMRC's position, resulting in an accrual to the tune of £4.3 million. Since January 2019, we've been working with NHS Digital to ensure their status determinations remain fair and compliant. As I said, NHS Digital relied on the CES tool, and CES has its issues, which we will come on to in the next few slides. So if you read the statement there on NHS Digital, it says, following the implementation of the new rules for the IR35 introduced by the public sector in April 2017, we undertook a considered assessment of the status for each individual contractor we believe met the HMRC requirements. However, HMRC have challenged our assessment. We've been in extensive discussions, but now consider it appropriate to acknowledge their position and create an accrual covering the period from 1st of April 17 to 31st December 2018. This accrual is 4.3 million, including interest and penalties. So you can see the cost of getting this wrong can be excessive. So how do you go about ensuring your compliance? Factors that you need to consider. First, you need to identify what the responsibilities are and what you need to do, who you need to assess. So what does the contractual chain look like? Where do you sit within it? And what are your obligations as part of the contractual chain? Who are your payroll workers? How many are there? And are there any critical to delivery of your key projects? Should these roles be PSCs? Who are the key stakeholders in your organisation that you'll need to inform or train? What you'll find as part of this off-payroll reform is it involves a large amount of communication throughout the business, between businesses and agencies, and between agencies and businesses and contractors. So it's something to be aware of. So one of the most crucial things to remember is ensuring that the arrangements you become involved in are genuine, that they're compliant. Some businesses in the lead up to the reform in 2020 and for the public sector in 2017 attempted to circumvent the rules by other means. The use of a statement of work, which while sometimes are appropriate, many businesses use these to try and falsely represent a provision of labour as a genuine outsourced service through a contractual agreement. However, IR35 looks at the reality of the arrangement, and so these would not hold up under compliance activity. Using false consultancy, so clubbing contractors together into a small company, believing that would, having one company with lots of limited companies within it would circumvent the rules. It doesn't. Trying to force small companies exemption by moving staff between companies. Again, HMRC are wise to all these type of things, and they will be investigating all the business that are involved, and they will go through the business with a fine-tooth comb during an inquiry. Using avoidance schemes which seem to be legitimate. If you feel like you're making use of a loose loophole, chances are you will not be found compliant under any scrutiny. I expect, and this is just my personal view, I hasten to add that in the next 12-18 months, HMRC's compliance activity will be centered around looking at arrangements that are there to, or are supposed, if you like, circumvent the rules. Outsourced service provisions, if an outsourced service provision is a genuinely outsourced service provision, that's perfectly fine. There's no issue with that whatsoever. But when it's a labour provision disguised as an outsourced service provision, then there would be clear issues. And those are the sort of things that HMRC will be concentrating their compliance activity, in my view, for the first 12-18 months or so following the reform in April. So when it comes to assessing and issuing status termination statements and assessing the status of your workers, what assessment options do you have? What tools are available to you? Well, first of all, you have CEST, HMRC's check of employment status. Now, as we've touched on the earlier slide, the NHS slide, NHS used CEST and it didn't work out very well for them. The problem with CEST is, as I stated back at the beginning of this presentation, in the ready-mix concrete case back in 1968, Judge McKenna set 3 key status tests: personal service, which everyone knows as substitution, control and mutuality. All 3 are present, you're an employee. Conversely, at least one is missing, you have to be self-employed. HMRC CEST tool ignores one of those key status tests. It ignores mutuality of obligations, so therefore the tool is flawed. HMRC CEST tool has been criticised by tribunal judges. It has a restrictive approach, and HMRC themselves deemed its results irrelevant in the inquiry. HMRC say they will stand by the outcome of a CEST determination, providing you've answered the questions correctly. Correctly is in whose view? HMRC stack the cards to suit themselves, and when it comes to CEST, they will ignore it if it doesn't suit their argument. Only 14% of contractors trust the tool, and results are indeterminate in 20% of uses. Then you have automated tools. The problem with automated tools is they don't provide consultancy or support. In-house teams often lack sufficient IR35 experience, could be seen as not taking reasonable care, lack of expert support in the event of compliance activity, and there's a liability risk. And then unashamedly, I'm going to plug our Qdos' status review tool, because our status review tool involves all parties in the chain. It applies case law. It's assessed by an IR35 consultant using holistic approaches intended. There's a result provided in 100% of uses, compliance support from IR35 status experts, 83% of contractors trust the result given, and risk is insured, which is a key part of any status review tool. So what should you look for in your chosen solution? First of all, you should check that the solution's compliant. Beware of the promotion of loopholes. I mean, you can have an offering that looks fantastic on paper, but if it's not actually compliant with what HMRC's guidelines and regulations say, then you need to think again and look for a different solution. Speed. Many recruiters will want something fast that won't slow down the onboarding process. However, you should be careful with tools which promote AI or digital decisions, as these don't provide a determination 100% of the time. And HMRC have been quoted stating that tools like CEST cannot be relied upon at a tribunal. So if HMRC are dismissing their own AI tool, then clearly they're not going to have much time for somebody else's. Is the business reputable with IR35? Check that you're putting in your compliance in the right hands. One of the big themes of the new off-payroll rules is reasonable care, due diligence. HMRC expect businesses to take due diligence at the start of the reform and to continue that due diligence all the way through the time they're engaging with contractors, and making sure that you're using a business that is reputable and is up to date with all the IR35 guidelines and regulations is important. Is the assessment process backed by insurance, and who is that insurance with? Our assessment process is essentially guaranteed because we insure the results with a specifically designed version of our tax liability cover, which we pioneered for contractors back in 2000. Essentially, we are putting our money where our mouth is. We're saying if you use our status review tool and that decision is overturned by HMRC, we will pay the costs if we lose the argument when we defend the decision. Of course, what traditional features does the system or tool have to help you with compliance? Beyond assessments themselves, does it help with dispute management, reassessments, role assessments, and so on? Remember, the tool has to have a built-in appeals mechanism so that the contractor can appeal against the decision if they don't agree with it. Finally, what support is available to you? Again, an AI tool will work to a point, but what happens if you've got a question? What happens if the decision comes out and you're not sure why it's come out this way? Who do you turn to? Who would you ask? So other elements you need to consider beyond just the assessments is, what are your policies and procedures? What are the terms and conditions? What are your business's usual processes? Communications, avoiding losing the contractors because they're not happy because they've not heard what you're planning to do post April 2021. IR35 reform preparation requires more than simply assessing all of your in situ workers. Compliance extends to all your policies, and these shouldn't be forgotten. So the top 4 mistakes made by businesses. Number 1, enforcing pay-as-you-earn only working. Whilst this is risk averse, 91%, according to the Qdos' status review facility, belong outside IR35. Insisting that contractors work pay-as-you-earn will not only increase the likelihood of a contractor walkout, but it's unnecessary and removes access to highly skilled and flexible workforce. Number 2, blanket IR35 determinations. They're non-compliant and pose a considerable risk to the businesses that enforce blanket determinations, and it doesn't take into account reasonable care and could leave the business with an IR35 liability. HMRC may come in and carry out an investigation to the workers you've engaged as a business. And if you have done a blanket determination, whilst you would have paid the additional national insurance, etc., that is due, HMRC might say, but you haven't taken due diligence, you haven't taken reasonable care in deciding these contractors' employment status, you've just made a blanket decision. So in theory, HMRC could charge you a penalty on the tax that you have paid, because they will say you have not taken reasonable care. So there's a risk that further liabilities will be due. Number 3, relying solely on CEST. CEST has been widely criticised. It's fundamentally flawed and overturned in tribunals, and there's even cases where HMRC have argued that the results should be thrown out. So HMRC argue against the findings of the tool that they've put out there for people to use. And number 4, leaving contractors uninformed. Not only should contractors be consistently informed, but so should stakeholders. A clear and transparent approach to the coming changes make it simpler and less disruptive process for all involved. Communication is key when it comes to the new rules post 6th of April. Everybody involved within the engagement chain needs to know what the business's policies are when it comes to engaging limited company contractors. So, what are best practices for ensuring compliance? Put knowledge and education at the forefront of your IR35 strategy. Maintain regular communications with suppliers and clients and contractors. Implement a robust, fair and transparent process for assessments. Ensure robust processes and procedures are in place with regular reassessments. You need to not only demonstrate that you've taken reasonable care at the start of the process, you need to be able to demonstrate to HMRC that you're taking reasonable care throughout the process. And that would mean regularly reassessing the employment status of the workers that you're engaging. You can't just do that once and then not think about it for the length of the contract. If the contract's 1 year, 2 years, whatever, you have to regularly reassess contractors' working practices to make sure they are still IR35 compliant, still outside of IR35. Our advice is you want to be doing this on a 6-monthly basis, twice a year. That way you can clearly demonstrate to HMRC you have thought about this and you have acted and you've taken reasonable care and acted with due diligence throughout the process. So what to do now and after 6th of April 2021? With only 6 weeks to plan and document your strategy, communicate this information and train staff and assess all in situ workers who will be providing services post 6th April 2021. You have a lot of contractors, you may want to simply start assessing your workers and circle back to the training and review policies and so on. Getting those status determination statements out is important to complete before the 6th of April. Workers, contractors will want to know how you intend to assess their status and what you believe their status to be before the 6th of April. They will want that level of certainty, and it's important that those status determination statements are issued to the contractors as soon as possible, because as I touched on earlier, if you as the engager do not issue the status determination statements, the liability sits with you until you do. So it's important for yourself and to avoid any risk of any additional liabilities that you get those status determination statements out to the contractors, and that the contractors have a way of appealing the decision if they do not agree with it. So what to do before the 6th of April 2021? Plan and document strategy. Finalise and document decisions on how you will approach the reform. Identify all in situ PSC workers who will be in contract from the 6th of April 2021 and identify supply chains and document responsibilities accordingly. Communicate and train staff. Clearly communicate decisions to all stakeholders, hiring managers, workers and suppliers. Educate internal teams on IR35 rules and status considerations. Provide training for stakeholders on business as usual processes. Assess your workers. Assess all in situ workers on a case-by-case basis and issue status determination statements to those workers. Document all assessments and any disputes made. Ensure SDS is passed to worker and next UK party in the chain. When it comes to IR35 employment status, you need to document all the things that you've put in place that clearly demonstrate that that worker is operating outside of IR35, operating in a genuinely self-employed way. Because if HMRC carry out an investigation and ask you questions, they will always want the evidence to support your answer. You won't be able to say, Mr. Inspector, this happens, and they will take your word for it. They will say, thank you very much for telling us that. Where's your proof? Where's your evidence to support what you're telling us? So what to do after 6th of April 2021? Maintain records of all status and policy decisions, ensure contractual arrangements are kept up to date and mirror one another. You can have the best and most compliant IR35 contract in the world, but if it doesn't mirror the actual day-to-day work in reality, it's not worth the paper it's written on. The contract should be an accurate reflection of what the contractor's day-to-day working practices are. Complete indicative role assessments when advertising for new roles. Contractors, when they apply for roles, will want to know if this role is going to be inside or outside of IR35, as that will then colour their decision as whether they want to take the role or whether they don't want to go for the role. Maintain regular training for staff and reassessment of workers. Thank you very much for listening to me today. And if you have any questions, I'm happy to take those now.